Alex here with part 200 of the My Docket series. Part 200, wow, of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. My mindset at the time going into this order granting motion to modify legal custody is that I literally cried. I remember going outside of the office because I couldn't believe what I was reading. It felt like finally I was able to get something done in my case, and the court didn't make it as hard as they possibly could. Finally, I got an order granting legal custody. I got sole legal custody, and I didn't even have to go to a hearing. The amount of stress and anxiety that comes off your shoulders when your child has been physically beaten, and the court says, not only are you going to get what you want, but I don't even want to talk to you, cannot be explained or described in words. For a person who has gone through years and years of having to jump through so many hoops and over so many hurdles with a legal system that does everything in its power to make it as difficult as it possibly can for you to get the relief that you need. To get a document like this had a huge, tremendous emotional effect on me. And I never forgot that day. I remember calling my wife in tears. I was like, not only are we done, this wasn't even the TPR. I was like, not only is this situation behind us, but we didn't even have to hire counsel. We didn't have to go to Reno. We didn't have to set a hearing. We didn't have to, sorry, got interrupted there right in the middle of the video. In any event, this is just gonna be something that we need to go into. So all that being said, let's go ahead and take a look at what the judge has filed. Order granting motion to modify legal custody and visitation. Standard introductory paragraph. The court's indicating that she has reviewed my papers and orders associated with my motion to modify legal custody. Findings of fact. Again, guys, disregard this. The court can't make findings of fact without holding an evidentiary hearing. Let's just call it the procedural history. The parties are the parents, blah, blah, blah. You already know the summary. This is just the fact that we share a common minor child and the fact that my ex was ordered to set these appointments and she hasn't done so. I'm seeking sole legal custody as well as supervised visits for my ex. I allege that my ex failed to respond to any of my requests, and I'm stating that by refusing to reply to my communications, the child's medical care is pointlessly delayed. I am further alleging that on February 10th, 2016, that Dr. Brian Nornsberg told me that our son has reported to him that she was hitting him in the face so hard he was bleeding. Conclusions of law, DCR 13.3. You guys are starting to see a pattern here. I love DCR 13.3. She's failed to respond, and therefore the court's going to treat her non-response as an admission that everything I'm saying is true and a consent to granting my request. Number two, given the evidence, there's no evidence. There's no evidence yet. We haven't had a hearing. Given the allegations of my ex's failure and or refusal to communicate in a reasonable way regarding the minor child and his health needs, my motion to modify legal custody is granted. I shall enjoy sole legal custody of the minor child, and now I get to just do everything that I want with regards to legal custody without talking to her anymore. She can retain information-only legal custody. Information only means she has a right to ask for documents. Generally, the court will review a contested motion for change of custody or visitation to determine if the moving party has made a prima facie case for modification. A party moving for change in custody must show the parents circumstances that have materially altered since the entry of the last custodial order, and the custodial change would be substantially beneficial to the child. The Supreme Court has not specifically addressed the standard of a moving party that a moving party must meet in setting a modification for visitation. While it's clear that motions to modify custody have to meet the standard in Ellis v. Carucci before a hearing is required, the standard for modifying just visitation alone is not as certain. I think that, honestly, I think she's wrong. I think that the Supreme Court treats a motion to modify visitation the same as a motion to modify custody. That's my opinion, but I might be wrong. In any event, it doesn't matter because, based upon the moving papers, the court finds that I have presented a prima facie case for modification of visitation. Anyway, the best interest of the minor child is served by modification based on the unchallenged allegations regarding physical abuse of the minor child while in my ex's care and custody. Thus, I have been able to do what CPS has been unable to do. By filing a motion, I was able to restrict all of her visitation rights with the child. In any event, she goes into the standard boilerplate that's included at the back of every single family court order, which is the boilerplate for abduction, concealment of a child. This is required by law to be placed in all court orders in family court. And we have the certificate of mailing indicating that this document was mailed to both me and my ex. Next, we have the notice of entry of order. This here is, as I mentioned in the previous video, it triggers the timelines for filing an appeal. If you want to learn more about the notice of entry of order, please watch my video on the topic, notice of entry of order. List of exhibits, exhibit 1. This is just going to be a court order that we already went through literally a minute ago. So as my policy in the My Docket series goes, I don't go over documents more than once in the series. If you would really like to take a look at what is in Exhibit 1, just go down into the description below, click on the link for yourself, download it, take a look. If you see anything in there that you think I missed, just post it down in the comments below. Order directing transmission of the record. This is a Supreme Court order, and this is a Supreme Court commanding the clerk of the district court to turn over each and every paper on file to the Supreme Court. They are now going to resolve my appeal on those attorney fees, and I know I've mentioned to you guys what's going to happen. It's not going to be pretty for the judge, but that decision will be coming down soon. Next, we have the certificate of clerk and transmittal record on appeal. The clerk is indicating, this is the district court clerk indicating to the Supreme Court clerk that the documents requested by the Supreme Court have been transmitted as ordered. Next document we have is WD-FCR 34, Notice of Pending Proceedings. I am giving this court notice that I have filed a termination of parental rights and a adoption action in the 8th Judicial District Court. Certificate of Rule 5 service indicating that this document was mailed to my ex. And then we have the notice of entry of order terminating parental rights. This is me letting this court in District 2 know what District 8 just did to my ex. I'm going to go over those details very soon once the timeline catches up, because those other proceedings are going to be addressed in their own videos separately. But you can, if you really want to read it now, if you can't wait, you can go ahead and go down in the description below, click on the link, download this notice of entry of order, and look at Exhibit 1, and you can read the order terminating my ex's parental rights. I know a lot of people have been waiting for this. But I'm going to discuss it in detail when we get to the actual termination of parental rights action, which is coming very, very soon. Just hang in there, guys. But again, it's down in the description below. Click on the link, download it for yourself, take a look. If you do have any questions on the order terminating parental rights, I would actually request that you hold on to those questions, because there's going to be a video dedicated just specifically to this process, and I'm going to want to deal with those questions in those videos that are coming up. Going into the aftermath, I filed 4 documents, but they were all free filing, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney at this point either, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.